Is it a good idea to update your estate plan after you get a divorce? The answer is yes, 110% yes. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you are seeking assistance in either estate planning or the administration following the passing of a loved one, we can assist. You can reach us at yourplanningattorney.com for a free consultation. We'd be happy to help. Now, I also want to mention that we provide this free education on a regular basis. So please ask questions and share so we can help some folks together. Okay. I said when you are divorced, should you update your estate plan? Really, you should do it during the divorce. Sometimes there's some nuances in the sense that, like, if you are creating a trust, you may not be able to transfer all of the assets because the divorce is still pending and you're not sure what's going to happen with them. However, it is important to make sure that as you're going through that process and you're still technically legally married, that person, should something happen to you, does not have the authority to make either medical or financial decisions or even be a recipient of the assets that are yours. That could be super tricky. If it doesn't happen during the divorce, because it's a process and not many people are, attempting to tackle both of those things at the same time, the next best thing is to take care of it after the divorce is finalized. It's obvious at that point which assets are yours, which assets are your ex's, and how to treat them going forward. And what obligations maybe there still are ongoing at that point. But to establish a proper estate plan at that level is super important, especially if you have minor children and no one, in your immediate family who's then sort of your automatic decision maker. And again, I say automatic with a loosely, because that's based on state law and who would sort of be the default. You certainly wouldn't want like an 18-year-old child even to be that decision maker, I wouldn't think. I know I wouldn't. So I wouldn't put that burden on my children at that stage. So, you have to decide, is it going to be your sibling? Is it your parent who's aging? Do you have a close friend that you're comfortable making those choices for you? But to put it in writing is critical because now you don't have that default structure so much. In addition, if you do have minor children and something happens to you and your ex-spouse, having guardians designated for your minor child is critical. And if your ex doesn't create a plan, then really yours would be, your choices would be held in highest priority when it comes down to that. I think that addressing these issues at that time is one of those life shifts where it's a good idea to sit down yet again with another attorney, but estate planning attorney is a little less more relaxing, I would think, than going through, the family law process. I might be biased because this is what I do for a living, but we try to make it easy for everybody. So again, we hope you've learned something new here today. I am Valerie Zammitti of Zammitti Law, and we provide peace of mind to you as much as we can through our education and through the services we provide to our clients. Don't forget, share, and as always, take care.